It's 2 o'clock time now for Inside the Courtroom, the Senzo Meyiwa murder trial wrap. I'm Linda Mnisi. An absolute pleasure to have you with us this beautiful Sunday afternoon. Now, it's been a busy week in the country's court, and that meant that the trial was moving quietly behind the scenes, and it is for that reason that we will be reflecting on key moments that happened in the trial this past week. But as always, we do have our poll question, and this week we are asking you whether or not you think that so far the state's case holds, and we've got a number of options for you that we have lined up, and that one is yes, the case is solid. Number two is Ntanzi poked holes on the state's case, and number three being you're waiting for the end of the trial. Remember, we love hearing from you, so make sure that you scan the QR code on your screen right now and you start voting, and those votes will be reflected throughout the show. You can also send us a WhatsApp message, and we'll make sure that we read all of those messages once, of course, you've sent them through. So start voting to ensure that your votes are reflected by using the QR code that is on your screen right now. All right, we start here. The alleged intruder of the Khumalo home, that's Bongani Ntanzi, returned to the stand on Monday to face further cross-examination. It's the state's case that Ntanzi entered the Khumalo home with the gunman to execute the alleged hit on the footballer Senzo Meyiwa at the alleged behest of his then-girlfriend, singer Kelly Khumalo. Now, this shooting happened in the Khumalo home in Vosloorus on the 26th of October 2014. But Ntanzi has denied ever being at the scene of the crime or conspiring to kill the soccer star. Now, on Monday, the state confronted him with his call records, attempting to challenge the allegation that he received a call from an investigator who identified themselves as Mfundisi prior to his arrest. Now, the court previously heard that Mfundisi was Sergeant Batu Mohola, who is part of the investigating team.
Can you indicate that number which you say called you?
I didn't come to court to assist the state with their case. I'm here to come and defend myself.
Well, we are putting to you that there is no number that either starts with a 01 or 02 number, so 012 or 011 for the period 1st of June 2020 up to the 15th of June 2020. If you want to differ with this proposition, you can have a look at the cell phone records and then comment.
Everything that was shown to me, the state is the one that produced and showed to me. There's nothing that I myself and my attorney brought before the court. The reason why I'm here is for the state to ask me questions, and I respond to the questions. Since the state said I had an alive Senzo, I did not bring any records before the court.
All right, I'm joined by my panel of guests. Mabalane is a commentator, and as you know, he joins me now in the studio. He's one of the people that believe that the 5 accused are the right people that the state needed to arrest, as well as Sibongiseni Gunene and Elton Hart, who are joining us via our Zoom link to unpack this evidence. And I want to start with you, Sibongiseni. Very good afternoon to you. Let's talk about why this issue of the call being a call that was allegedly made by Mfundisi, who asked, are you still looking for employment? And now it's important to highlight that this is before Bongani Ntanzi's arrest. Why is it important in the bigger scheme of things?
Good evening, Linda, as well as the guests and your viewers at home. The call is, I think the importance about the call, what Balo is just trying to do, it's a matter of credibility, and insofar as that evidence is concerned, taking into consideration that Ntanzi said he received a call from a strange number being 012, if not 011. We had those two there. You remember the version that was put by Mngomezulu, if I'm not mistaken, is the 6th, is not the 7th of November 2023, when he put that version to Sergeant Mahane, not Imhan. So Baloyi is trying just to say to you, to Ntanzi, this could not be true, and we are just fabricating evidence unnecessary so, because Mkhula could not just call you. Why Mkhula was supposed to call you? Because he was not even assigned to investigate your case. Nonetheless, that is forming part of the cold case unit. If you remember, when Mngomezulu put this version on the 6th, if not the 7th, to Sergeant Mahane said, I don't know anything about this call, and it's very strange. And if this call should have happened, I was going to receive such an information from Sergeant Mahane that he has communicated, that he has communicated with Ntanzi, and taking into consideration the seriousness of the offense. Is there any likelihood of this thing to happen that you can notify somebody who is a suspect that the police, they just want him, and you can't just alert somebody who's going to run away or even hide. So you're complicating your issues. It's impossible. In fact, this is a basis which Baloyi is trying to lay for the purposes of argument at a later stage.
Yeah,
I think so.
Yeah, let me come to you, Alton. I mean, I'm wondering why it was important for Bongani Ntanzi to mention it even in his evidence in chief. Is it so that at a later stage he argues, that his arrest was perhaps unlawful? Help us make sense of what it does and the benefits for mentioning it when it comes to Bongani Ntanzi's defense.
Now, when one looks at when a witness is now, or an accused person is giving evidence in his examination in chief, whatever his legal representative have put to the state's witnesses under their cross-examination, it should line up. Because then if it doesn't line up, it will mean that why would your legal representative put this to one of the state witnesses to say, receive this call, but you on your own don't mention that call if it was so important to actually put it to them so that it can show, it speaks to your credibility so that it lines up. So it's important that whatever was, and this famous word when the lawyers say, I put it to you, those things must also come out of your evidence in chief in order for it to line up. Because if it doesn't, then it will seem that something was put to a witness, and now as the case unfolds, you realize that that thing is actually not important or it's not critical to your defense, and now you're not going to mention it so that it doesn't be it doesn't get canvassed with you also under cross-examination by the state. So I think it was important in that aspect for him to say that, listen, yeah, I need to mention it. And I'm now not even going into it, is it true or not true? That is still something for a later discussion. But for now, that's normally the reason why it should line up what was put under cross-examination to state witnesses with what is currently in your examination in chief. And I think now in cross-examination, Advocate Baloyi is now trying to deal with that aspect as well, to say, but it could not have happened. And then we'll check now to see what type of answers he gives now when he's cross-examined about it.
Yeah, Mabelane, let me come to studio with you. I mean, it seems the state is going through the records and saying, well, there's an issue of whether this was a private number, because in evidence in chief, he initially said he had received this call from a private number prior to his arrest. This person asked him whether he was still looking for employment. But now there's also the issue of this possibly being a 011 number, meaning it is a Joburg number, or a 012 number. Talk to us about how you, as somebody that follows this case, are placing and where you're placing this piece of evidence.
Yes, I do agree with the fellow panelists that it has to do with the credibility of Ntanzi. And to Mr. Hart's point, there is a problem of misalignment from the version that was put by Mngomezulu. Because if we unpack it a little bit, Mngomezulu, when he put the version initially, he said they called with a 012 number. Later on, Ntanzi says, no, it's a 011 number. And when he was confronted with Mgomezulu's version, he says, no, it might have been 011 or 012 number. And another problematic version is, Ntanzi said, a person who called me introduced herself as Mamfundis. And then later on, he says, no, in fact, he introduced herself as Mamfundis and later Mohola. But then it was the testimony of the version from Mgomezulu that said, it is in Ntanzi's instruction that the person introduced herself as Sergeant Mohola. But Ntanzi on the other side says, I got to know of the name Sergeant Mohola after I was arrested. So that version is really problematic and is eating into the credibility of Ntanzi.
Yeah, you speak about the issue of credibility because, you know, one of the questions that he was asked at a later stage was around why he was taken to Carltonville. And he says the allegation there was that, you know, he was a person, you'll correct me if I'm wrong, a person who lives in Vosloorus, owns taxis or drives taxis. So does it reconcile with then a person that called much earlier before your arrest and asked if you're still looking for employment?
It doesn't, because it is his version, you are right, to say the reason he went to Carltonville, which is Sibanye, is because he was told by the investigation team when they were interrogating him that he is having taxis and staying in Vosloorus. But then the question was, why was the purpose of going to Carltonville? He said, it is to prove that I am employed. And then Baloyi said, but then if you want to prove employment, you must go to Impala in Rustenburg, not Carltonville, because we are not employed there by Carltonville. In any case, it's evidence before court. We know Carltonville, they've dismissed him because he misused leave days. So why would he want to go and prove employment there? So that's another version that is crumbling.
So, the state appears to be wanting to, you know, attend to possibly every single thing that might have been mentioned by Bongani Ntanzi. And I sit, you know, wondering, watching the proceedings, thinking to myself, is it because they've got the burden of proof, right, to prove beyond reasonable doubt that there shouldn't be any story that arises from Bongani Ntanzi that is later corroborated by another witness without them having challenged what Bongani Ntanzi said?
I think currently what is happening there is Baloyi is just putting each and every version of the witnesses of the state. If you remember very well, when we came from recess, he was dealing with Sergeant Mhani's evidence and this version insofar as Sergeant Mhani's evidence is concerned. And also now he looks like to be visiting also Gininda and the rest. It's not like maybe he's just dealing with all pieces of testimonies or version that he put. I think it's just putting the version of the state who testify to him that this is what they said. Remember that at the time when they were testifying, Ntanzi was just seated there and putting some version. Now the state is putting the version of these witnesses who have already testified to him and say this is what they've said, and then can you provide an explanation thereof? And I don't think it could be something that is associated with the burden of proof or proving beyond reasonable doubt. It's just putting this version of the witnesses of the state.
All right, let's take a quick ad break, because when we come back, I want us to look at the issue around the notice of rights and charges. So that is an important conversation, looking at what Bongani Ntanzi had to say to those questions. So don't go anywhere. Welcome back, and thank you for choosing to stay with us. You're still watching Inside the Courtroom, the Senzo Meyiwa murder trial wrap. Now, Bongani Ntanzi insists that he was charged for the murder of Senzo Meyiwa. Now, this despite the lead investigator previously telling the court that he was only charged for the murder of Senzo Meyiwa on the 26th of October 2020. Now, Ntanzi says he was never approached to be charged on the day, and that the police only came on the 27th of October 2020.
On the 16th of June 2020 at 22:45 in respect of Nongoma 163/10/2018, you'll recall when we showed you your signature on this exhibit LL1. You said, Sergeant Mokhani, you appended the signature, but Sergeant Mokhani told you that he's charging you for the murder of Senzo Meyiwa.
Yes, because I don't have a case at Kwanongoma. Even now, I've seen the police officers from Nongoma at the prison fetching somebody else.
And we then referred you to the evidence of Brigadier Gininda, which appears on page 25 of the proceedings of 15 November 2024, wherein he testified as follows at line 8. He says, but for this matter, he processed him on the 26th of October 2020. That is when he was processed for this matter. That is now the current case.
Let's continue this conversation with my panel of guests. Mabelani is joining me in the studio, a commentator as well as legal analyst, Sibongiseni Gunene and Alton Hart. Gentlemen, thank you very much for your time. I'll start here in studio. Mabelani, it starts with the notice of rights and right to the charges. And of course, the context here is that according to the lead investigator, Brigadier Bongani Ntanzi was only arrested on the 16th of June in relation to the Nongoma case, right? And only at a later stage in October 2020, on the 26th of October 2020, this was now, 6 years since Senzo Meyiwa died, was he charged with his murder. But he says from the onset, I was charged with the murder of Meyiwa. Just talk to us about the issue of the notice of rights, because when he's charged, he would have had to be notified of his rights.
Yes, so when he was arrested, he was given a document to sign which had his rights. And then he signed. That's why Baloyi is asking, whose signature is that? And he said, it's my signature. That document is the document that he signed when he was arrested. And the case number listed there is the Nongoma case. So Baloyi was saying to Ntanzi, it cannot be that you were arrested with regards to the Senzo Meyiwa case when the document we have signed, it is the Nongoma case. And remember previously, during a trial within a trial, when he was told this, he said he was an illiterate, trying to insinuate that he couldn't have read that it's a Nongoma case that he was arrested for. But then we know that the document he signed, it is with regards to that. But then in terms of arrest, Mgomezulu put the version to Mohani to say, Mohani, according to Ntanzi, that's after he consulted with Ntanzi, according to Ntanzi, you charged him on the 26th of October 2014. And Mohani said, that's correct, I charged him on that day. But now, Ntanzi is on the stand, he's saying, no, in fact, what Mgomezulu has said is not true. What is the true version is that I was arrested on the 16th of June 2014 and charged for the Senzo Meyiwa case around that time. So it is a credibility issue as well, because he was sitting there, raising up his hand, giving Mgomezulu instruction, but now he's distancing himself from that version.
Alton, I mean, if Ntanzi's answers are anything to go by, then it would really raise questions around what Brigadier Bongani Ntanzi told the court was, the strategy that was implemented here, the cold case analysis, getting to know who the people that were involved here were, and then ultimately bringing them close. And by bringing them close, he says, we arrest them on unrelated matters so that we bring them closer, and we can then question them about this particular case that we want them for.
No, indeed. I mean, that's an old strategy. Obviously, if you have cases of an accused person, you're busy still investigating another one. Nothing stops you in law to say that I can arrest you. And in Bongani Ntanzi's case, on the Nongoma case, that he was arrested, and then later on, while he was still in custody on that case, he also gets charged with the Meyiwa offense. There's nothing wrong. There's nothing untoward. And I mean, it's also easier, say for instance, if I have a person in custody and I need to actually sort of half serve him with another doc or a summons or a subpoena, whatever the case may be, it's just easier for me to get a hold of him. And also, it doesn't say when you can actually start asking a person about a specific other offense. It doesn't mean just because I'm arrested for the Nongoma case, I can only be questioned about it. They can say, but we also have another issue here. Where were you on this specific day? Because there's another offense that we are looking at, and we have maybe information that you can be a person of interest. So that doesn't stop them from that. The thing for me, yeah, and I think this is what they were supposed to do under cross-examination of the state witnesses. One had to ask them to produce the rights, that paper, the document that your rights that is read out to you, and you sign it on the day on which day he signed it, and then look at the Meyiwa case and say, for that case specifically, when you were also warned of your rights, that you do not need to incriminate yourself, when did he sign that? And then you bring those two. And I think that was something that they had to canvass on the cross-examination, but they did not.
Yeah, and I want to hear your views, as Bongiseni, on this aspect that is raised by Alton and the strategy that he believes should have been used.
You are talking about the rights.
Yes.
The notice of rights, I don't know if you're talking about it.
Yes, the notice of rights.
I think, if I remember very well, that is Exhibit L. And there is Exhibit L, those are the notice of right in respect of Nongoma cases concerned. And there's notice of rights, not a paper, whatever. It was produced during the trial, within a trial. And Ntanzi also was cross-examined at length, if I'm not mistaken, by Dr. Sibanda. He was cross-examined about it. And then insofar as the one that has to do with Senzo Meyiwa, if I'm not mistaken, also that one was also produced. And because Baloyi also referred to it this week and said, remember that there is also exhibit, I think it's LLL, and this one which were then signed on the 26th. So then all those information has been canvassed, if I'm not mistaken, during the trial, within a trial at length. If you can go to the evidence where Ntanzi was being cross-examined by Dr. Sibanda, then you are going to see those things. Even Sergeant Mhane, when he was testifying on the 6th or the 7th, at some point, there was a time when he wanted to refer to his docket where he's going to just to uplift one of those documents, being the notice of right, when I think he was asked about interpretation, whether can you just translate this thing into Zulu and refer to one of the notice of right, or maybe just one paragraph or whatever, then and interpret it in Zulu. It's there. And he was taken into task about it during the trial, within a trial.
Yeah, and Alton, let me come back to you. The issue around when exactly he was charged, for the Meyiwa case, it seems the state also is going along the lines of using records to try and disprove any version that Ntanzi may come with. In particular, when you look at what he said about, in response to the records of November 2023, where his then lawyer, advocate, or Thulani Mgomezulu, in fact, asked him or consulted with him about, when exactly the arrest happened. He comes back and he says, well, it was on the 26th. But now on the stand, he comes back and he says, well, on the 26th of October, there was no police officer that came to me. I was only approached on the 27th of October, which then appears to be him distancing himself again from what his lawyer had done, consulted with him and told the state witness at the time.
Linda, you would see, and that's why I say this misalignment comes in, where I say that maybe under cross-examination, and my colleague referred to it now with the notice of rights. And for me, for them to canvass that type of things, they should have done it when they were cross-examining the state witnesses back then already, and then align what you have put to these witnesses with what your evidence in chief is. And I'm not now saying he should sort of have fabricate information to align with his version, because if a version is put to it, that means that that was the instruction that was given to the lawyer, and you should stick to that instruction, because significant deviations and even distancing yourself from there while you were sitting in court when these things were, you had an opportunity to say, but that is not really my instruction. So then it would then says, but can we really trust what you are saying now under cross-examination or what you said under examination in chief, and that then says you are not a reliable witness, and then it will eventually boil down to the court making a credibility finding against you. Although the majority of the evidence is like sort of, there's not like direct evidence, but it's circumstantial evidence, and they are packing them nicely into actually sort of have now fit the narrative that the state has sort of started with how they want to present their case. And that is the things that one needs to look at Ntanzi and how he presents his evidence now under cross-examination compared to what they put under cross-examination to the state's witnesses.
Yeah. Sibongiseni, do you think the challenge with Bongani Ntanzi is the issue of too many versions?
That is 100% correct. I think maybe if it should have happened earlier during whether the consultation, whatever, just like the Capitec statement, you can mention the rights and all the version that you are going to put, you check it with the accused person before you're going to put it. Because as things goes on, it looks like that the accused has to then just to find a way to align himself with the version that are already there. There are so many versions that have been put. And that is why I think he finds himself to be trembling insofar as the evidence is concerned, because you find yourself, now he has to say, no, I think this is how my lawyer at the time was investigating the witness. This is his way of investigating, because you can notice now that this version, he does not know it. But he has to answer. He does not have an option. He has to answer to it and explain. Because the assumption is that of when the attorney or the advocate was putting the version, is that the version is coming from the said accused person being him. So those versions are the ones that are making some problems for his evidence insofar as the credibility is concerned.
Yeah, and quickly, we've run out of time, Mabelani. I mean, when you look at how he answers, right, it could be that, you know, that's how my lawyer was searching for answers from the witness. What do you make of how he gives those kind of responses?
The problem is something that is happening in that court we have never seen anywhere, where lawyers take instruction on the fly. Like, they take instruction now. It's not planned. They don't have a strategy. They get the instruction as they are going. That is the problem, and that is why some of these versions are not familiar to him, because they are tailored as they go.
All right, so don't forget to engage with us throughout the program. Our WhatsApp line is 072-110-558-4. That is the number that you need to make use of throughout the show to get in touch with us. Let me repeat it for you. It's 072-110-558-4. So get in touch with us. Make sure that you send us your WhatsApp messages. If you have any questions for my guests who are in studio, use the number that is on your screen right now at the bottom of your screen. Again, 072-110-558-4. We'll see you after this. Welcome back. Let's check in with the poll question that we're running for you this afternoon. Now, we want to know from you whether you think, based on the cross-examination so far, has the state managed to sustain its case against Ntanzi? We have those options on your screen. Yes, case is solid. That's 45% of you saying and agreeing with that point. 19% saying no, Ntanzi has managed to poke holes in the state's case, but 36% of you also saying we're waiting for the end. So it's quite interesting watching those figures, right, between the people that believe that the case is solid and those that are just saying, wait, hold on, I might just have to wait till the end. 19% being the lowest score of people who believe that Ntanzi has managed to poke holes. So continue to scan the QR code on your screen and get in those votes. We're tracking them throughout the program, and we'll make sure that, of course, we show you the final results. But also, like I indicated at the start of the show, you can engage with us via our WhatsApp line. The number is on your screen right now. 072-110-5584 is the number that you need to make contact with us on. Send us all your messages and some of the questions, if you have any. I've got my guests in studio with me who will be, of course, taking those questions, who will be reacting and making sense of the evidence that we have heard so far. So I brought them in so that they can ask you all of those questions. But of course, one of the things that we looked at, or one of the things that we heard this past week, is around Ntanzi being taken to Carltonville and the reasons for why exactly he was taken there. I'm still joined by my guests to unpack this. And I want to start here in studio. Mabelani, this is quite, a contentious issue, right? Because also this is the start of the confession statement. This is a tricky part because it speaks about who did what, the reason why they went there, and how the outcomes of that particular visit to Carltonville, to the mine in Carltonville, where Bongani Ntanzi was employed, ultimately influenced or was a trigger point to certain things happening thereafter.
Yes, that visit, it was a trigger point because the alibi was not supported. The HR record demonstrated that Ntanzi was not at work. And it is at that point when Kininda confronted him with the identity to say, this person, I've got, believe that you are involved in the murder of Senzo Meyiwa case, and then look at this identity, this person resembles you. And it was at that point that the foundations for confession was laid, because Ntanzi, his answers demonstrated that he is starting to talk. And Kininda asked him if he is willing to say all that in front of an independent police officer. And that is when Kininda started making calls for the confession to be taken.
Yeah, and of course, Sibongiseni, what then came before that would have been the meeting that was held on the 17th of June 2020. This is a day after Bongani Ntanzi's arrest. And there is a picture that he says he was shown, picture 47, which was then derived from the downloads of accused number 3's phone. And he says that, the person that they showed him there, they said it was him, when in fact it was accused number 4, Mto Goziseni Mapisa, right? And essentially, it all boils down to when the pictures were obtained of accused number 3, and when actually the police got to know about Bongani Ntanzi's alleged involvement in the murder of Senzo Meyiwa.
Well, we remember that accused number 3 was arrested in 2015 and for the Cleveland Alexander case, and that is when his cell phone was downloaded. All right, that is when then SAP has the pictures. But this is the difference. The difference is that Kininda know nothing on Hola, on Pane, or whatever the people who are involved in the case of Senzo Meyiwa. They didn't know at the stage they were appointed that accused number 3 is implicated in this case. And it does not even suggest that they could also have been in possession of this information, and for whatsoever reason, there's no justification for that. And you know that when they learned to be aware about that Ntanzi was involved in this case is when they were approached by Zungu, and Zungu Senior, to be precisely, making the statement. And that is when they became aware about Ntanzi. Not accused number 3, nothing, anything related to accused number 3, they had knowledge of it at that time. So then when now they approach accused number 2, whether in the boardroom, it does not mention anything as well again in terms of accused number 3 being involved. So there is no possibility that the police will show accused number 2 the pictures of accused number 3 by then, because they had no information, no knowledge whatsoever. If then the police had knowledge about accused number 3 and 4 and 5 by then, when they arrested accused number 1 as well as 2, why then they've never arraigned them simultaneously? So because there is absolutely nothing that was stopping them to do that. So it then become impossible that Ntanzi was shown a picture of accused number 4, which was then extracted from the downloads of accused number 3. So that version, it's become problematic for Ntanzi, because they have a chain and sequences as to how they learned about these people and when they get the pictures. And when they get the pictures, remember there is an affidavit that has been deposed by Mr. Mabasa. It has a date as to when it was deposed. It's even been a long time after Ntanzi has been arrested. So it suggests the impossibility of a picture that was extracted from the downloads being of accused number 3, which was shown to accused number 2. That is impossible.
Yeah, let me come back to you, Mabelane, because if, Ntanzi's answers are anything to go by, then it would mean that police would have known prior to him deposing a confession statement who was involved, and, whether or not the pictures existed, right? Because from what we've been told in the trial, at least, is that the names of accused number 3, 4, and 5 first came out of the confessions of Bongani Ntanzi, or alleged confessions of Bongani Ntanzi.
Yes, the evidence before court demonstrate that before that time, only 2 accused were known to have been involved in the murder of Meyiwa, which is accused number 1 and accused number 2. Only after Ntanzi has made confession and he listed accused number 3, 4, 5, it is then when Gininda started following the confession, he realized that accused number 3 was arrested, and he then inquired what was he arrested with. He realized that there was a firearm and a cell phone. A firearm was assessed by Mangena. The cell phone was done by Mabasa, like Spongiseni is saying, and that was done in August of 2014. So if in June 2014, they didn't know that particular picture existed. It is only in August when Mabasa submitted to Gininda the report to say, this is what I've analyzed, then that picture come into play. So it could not have been that he was shown that particular picture. And the state is going to argue that Ntanzi is not credible based on the other credible issues that they have highlighted, that he must not be believed in this case.
Yeah, Elton, I see we have you back. It's interesting because we were talking about the issue around Bongani Ntanzi saying that when he was in the boardroom on the 17th of June 2020, the day after his arrest, he was shown a picture that we now know is picture 47, showing accused number 4, and they said this was him, and he told them that this in fact wasn't him. It later emerges that this is accused number 4, Mthokoziseni Mapisa. But the other aspect that also came out is the issue of the ID kit, which, according to the state, he was approached by Gininda outside Carltonville, with the ID kit, when he said to him, I have reasons to believe that you were involved in the murder of Senzo Meyiwa. But that is also a disputed point by Ntanzi.
No, obviously, and I mean, this is all part and parcel of how Gininda was going about his investigation with the assistance of other people. And obviously, if he's confronted with evidence, that is what it is. But for me, it goes back to, if you want to now, under cross-examination, to say that I was forced or certain things, or there was maybe underhandedness, these things should have been raised with the state's witnesses when they were on the stand. Because if you did not raise it, it's like already you're missing one opportunity to actually raise these things with them. And then, for me, then looking at it from the outside, then it says now, okay, now you've heard the state's case, you hear how the state is planning to actually prove, based on the circumstantial evidence that's available, that you were involved in the commission of this offense. Now, suddenly, you start, when you have an opportunity and the examination in chief, you are sort of half tailoring your evidence to actually fit in with the version that you want to put before court and try and rebut what the state's evidence is. And knowing now that the state has already called the witness, they've played their hand. And now, when Advocate Baloyi is going back in the record and saying, but your attorney or advocate, depending on where we were in that specific areas of the trial, put certain versions. And you said there, and you didn't say anything about these versions that was put, that it's incorrect. Now to come and flip-flop on these versions, then again, it speaks to his credibility. And it might then mean that the court will say, I'm going to reject all your evidence that you gave under examination in chief, and I'm going to actually accept the version that was put there by the state's witnesses as the most reasonable, a reasonably possibly true version of what happens there. And we know that the state needs to say beyond reasonable doubt, but it's not like absolute. There must be no doubt at all. It's just reasonable doubt. And if the magistrate makes that exercise, then they might come to that conclusion to say, reject in total Ntanzi's evidence.
Yeah, and I'll quickly ask you the question I asked Bongiseni earlier, because it seems with every aspect and every, portion of Bongani Ntanzi's evidence that we touch on, there seems to be the problem of perhaps there being more than one version. Because, for example, I'm looking at, the issue around how many times, he saw Gininda. Did he speak to him once or twice? And the state challenging him on, the versions that would have come out before.
No, that's, and I think Mabalani is correct in saying that as he goes along, he's tailoring actually his evidence to actually suit his needs for that specific purpose. And that in itself doesn't sit well for you. And I'm not saying that the guy is lying out and out, but I'm just saying the fact that you start tailoring your evidence then speaks to which version is actually the true version of events that happened, and the versions that you put to the state, because now the state will be prejudiced by you now tailoring or giving another version that was not really put to them, and they cannot test it. And then it goes down to that point where a court will say, too many versions, I need to now look at which one is reasonably possibly true, and based on everything you've given me four, the state has given me one, and they've stick to their guns, even under cross-examination, they stick to this version, then I need to say, I reject your four versions and I take the state's one version as the one that's most probably have happened on that day, or how things has unfolded on that day.
All right, gentlemen, hang 10, because when we come back, we talk about the state's bid to cross-examine Ntanzi on his alleged confession statement. So stay tuned. All right, welcome back. Now, the state wanted to venture into confession statements that Bongani Ntanzi allegedly deposed. Now, you'd recall that according to the state, Ntanzi made two confession statements implicating himself as one of the intruders of the Khumalo home on the night that Senzo Meyiwa was killed.
Are you intending to cross-examine the gentleman on the contents of the alleged confession?
Yes.
All of it?
Yes.
Is that allowed, sir?
We get into that. My Lord, in light of...
address me, because I haven't made a ruling, you remember?
Yes.
And I've heard the evidence, right?
Yes.
And you have cross-examined, right?
Yes.
And we know that in terms of several laws, that the proceedings of a trial within a trial, they are compartmentalized,
yes,
as they put it.
Yes.
All right?
Indeed, my Lord.
So you can't cross-examine again, in my view, after or before I have traversed that evidence regarding whether I'm going to make a final ruling or not regarding the evidence which was adduced, elicited in a so-called alleged confession.
All right, let's bring in my guests now, and I'll start here in studio. Mabelani, one would think that because Baloyi has the alleged deponent of the confession statement on the stand, then he would be able to cross-examine him on the confession statement.
Yeah, I really don't know where Rata is leaning towards or which law he wants to apply. Maybe he will educate us, because according to me, the law is very clear, Linda. You cross-examine the witness based on any evidence that is before court. the confessions are admitted as evidence before court. So the state can cross-examine, and Khumalo was right. Remember, during a trial within a trial, Sibanda wanted to cross-examine the accused on the confessions because they are distancing themselves from the confessions. And the case of Potwana is very clear to say, yes, you can. And we have seen it in Joshlin case where Judge Erasmus presided over that matter. When Buddha and others, they distanced themselves from the confession, the state said, according to State versus Potwana, we can cross-examine them on the contents of this confession to prove that this is from them. And then Patarata said, no, you can't. You can only cross-examine after I've made a ruling. He has made the ruling. They are now before court. He's saying you can't. The question is, what law does he want to apply in that case? But we'll wait and hear his view.
Sibongiseni, what are your thoughts? Do you think there's a misunderstanding of perhaps where Judge Rata Mokwatling is going with this?
Yeah, possibly. That's what I thought when he was stopping Advocate Baloli. I thought maybe he does not understand where he's going, but nonetheless, there is already a ruling in the same court which is existing wherein Muzi has been cross-examined from his confession that has been found that it was made by him. Because the law is very clear. When you speak about the law, the reason we have a trial within a trial, we want to ascertain whether the evidence will be admissible and be used in the main trial.
Yeah.
Using the evidence in the main trial, it simply means that it can be subjected to be tested. And the state wants just to prove that other than you, Ntanzi, there could be no any other person who has deposed this information amongst others. Maybe let me just make an example. I had a small firearm and Mapisa was outside and Muzi was standing outside. You see, this information is supposed to be an exclusive information.
Yeah.
Now, then the state has to prove that information. Then they has to cross-examine the said accused person from the statement. I think maybe when tomorrow he might reconsider and say, maybe I made an error here. Then I need to allow you to cross-examine the witness from the said statement.
Yeah. Elton, let me come to you. I mean, we saw the state cross-examining Muzi Sibiya on his alleged statement. The only time that the state was not allowed to cross-examine Sibiya was when they wanted to venture into Bongani Ntanzi's statement, and that was not allowed. So what do you think is at play here?
For me, when one looks at this thing, the court has already made the ruling to say that these confessions is admissible. Now, there's no turning back now. The moment you say something is admissible, it means it's relevant and it can be used in the main trial, because that's why you have a trial within a trial. So I don't know, is the judge now second-guessing himself to say that finding of mine on whether these confessions was actually allowed to be, or whether that I was supposed to find that these things are admissible. Maybe I might have made a mistake to say that they are admissible. Maybe I should have said they are inadmissible. That's the only other thing that can say you cannot do that. Because the moment he makes that ruling to say it was not done under duress, it was freely made voluntarily, and they complied with Section 219 and 217 of the Criminal Procedure Act, then I think we are good to go. Now it's open sesame for the state. They can actually venture into those things as to why did you make these types of things. So for me, he needs to come and show us now the exception that he finds in law. But the only thing that I can think is that maybe in the back of his mind, he thinks that he made the wrong ruling to get those things admissible in the first place.
All right, so we did call for our viewers to ask some questions, and I believe we have a WhatsApp message from one of our viewers, which we'll read right now. So it's coming from Subusiso, all the way from Mpumalanga, who says, "Good afternoon, Linda and your guests. My question is very simple. Why wasn't Kelly charged? Cleaner that was called and cleaned the blood those are the questions that are coming from, the viewer who is Busiso from Mpumalanga. So essentially asking why wasn't Kelly charged, and the cleaner that was called, as well as the cleaner that cleaned the blood, why were those people not charged? Because ultimately, for cleaning the blood, that's from the viewer there, it would be viewed as defeating the ends of justice. Quickly, Mabelane.
Yes, the reason Kelly Khumalo was not charged is because of the strategy that Baloyi has taken. If you remember the case of Shova and Malapane was charged alone, and once he was dealt with, they went for the mastermind. And even in this case, Kelly as the mastermind, she's not charged, although there is an evidence that demonstrates she communicated with accused number 5 and also have saved this number in his cell phone. In her cell phone.
Yeah.
That's the reason why she's not called. It's a strategic approach.
Sibongiseni, what are your thoughts? Quickly, we've run out of time.
I think those are the same thoughts. It's a matter of a strategy. We all know that in terms of the SAPS had an intention to pursue her. J50 was already prepared. Unfortunately, then the prosecution said, wait, not at this time. So it's something that could happen in future. But insofar also as the one who cleaned the crime scene, and that could be a separate charge. It is insofar as defeating the end of justice. As to whether he had knowledge about the murder that was going to happen, you can't just put common purpose to her. You see, then I don't think it will be wiser to put him appear within this accuse and put him under the common purpose.
Yeah, let me come to you quickly, Alton. We've run out of time. What are your thoughts on this question?
I think it can be strategy, but also sometimes, me being devil's advocate, I can also say that maybe they are not really sure that they have something convincing against her to actually convict her. And that's why they didn't charge her with these ones. Because for me, I would have charged her with these ones and not follow the strategy to say, I want to get the 5 first and get her. I would have charged her with these 5 and dealt with them in that way if I was the person. But obviously people will see it from a different light, but I see it from that perspective.
All right, gentlemen, let me thank you very much for your inputs. And I want us to quickly go to your WhatsApp messages before we close the show. Remember, we did ask you to send in those messages. Mukwena in Palabura says, Linda, if Baloyi had played the magistrate's voice recording, Ntanzi was going to deny that was his voice. Well, interesting one coming from the viewer that, of course, is sending through those, messages. Let's check in with your poll results at this moment. You recall we asked you to vote, and our poll question is up. Do you think the state has sustained its case against Ntanzi? 47% of you says yes, case is solid. 16% of you saying no, Ntanzi poked holes, while 37% of you saying we're waiting for the end of the case. Interesting results this week, seeing that there was no outright majority. But of course, those poll questions, we keep them on the show every week, so make sure that you, of course, vote on them. So tomorrow we're expecting to hear the arguments by some of the lawyers, or of course the state arguing to cross-examine Ntanzi on his confession statement, while 2 of the 4 defense attorneys, of course, arguing against. But you and I will catch up again next week on Sunday, and when we reflect on, of course, the week that was. Until then, have a good one.